Hi, welcome to the It's Your Money and It's Your Estate Spring 2025 Workshop Series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Now let's take a quick look at our website, iyme.org. On our homepage, you can easily view our schedule, which has all the information for these webinars, as well as the in-person workshops. You can also register for these webinars straight from the homepage. Now, if you click Workshops and select the series of your choice, you'll find the topics for each of the weeks of the program. Each of those pages will have the recording of the webinar, which is usually posted about 3 to 4 days after the live webinar airs. Underneath that, you'll find the general workshop documents, which are our workbooks, which will guide you through the series, our booklets, as well as the very important Ask First form, which is very useful anytime you want to retain someone's services. Depending on the location where you take our classes or whether it's an online webinar, you'll find the speaker's presentation as well as their signed Ask First form. If you scroll all the way to the bottom, you'll find a selection of updated articles curated by Peter Kote, which are relevant to the topic of the day. Lastly, I want to go to our sponsor page, because without the support of our charitable sponsors, this program would not be possible. Now, let's start the program. This webinar is the first session of the It's Your Estate 6-week program. The topic of the day is Overview and State Law Changes. Our moderator is Peter Kote. Our guest speaker is Fred Muscarella. And this webinar is brought to you by Sigastrom Center for the Arts. Enjoy the workshop.
All right, Fred, come on aboard.
There we are.
Good morning.
Good morning. How are you today?
Good. Fred, why don't you put your Ask First form on the screen so we can introduce you? Fred Muscarella is an estate planning attorney, and if you can enlarge in that just a little bit, I believe you can. There you go. By the way, you have a master's or other advanced degree. Give us a little educational background on yourself.
Yeah, so I have a bachelor's degree in finance. I have a Juris Doctorate, which is, I went to law school, graduated law school. And so that's what the advanced degree is, a Juris Doctorate.
And so you've been practicing for 18 years. In what area of the law have you been practicing in this area, or in whatever area you're telling me?
Yeah, so I practice primarily estate planning, trusts, probate, anything that goes before the probate court.
And all your experience for the past 18 years has been in that area?
That's correct, yes.
Okay. Why is that important?
Well, when you go to a professional, you want to make sure that they know what they're talking about. Somebody, you wouldn't, if you were going to the doctors and, you needed surgery, you wouldn't go to a general practitioner, you go to a surgeon. So
Yeah.
you got to go to somebody that knows what they're doing, that has experience, that has been through it, countless times, and they can give you the best advice.
Yeah, you have kind of a unique experience in the estate planning area, and that is that you have been involved in litigation for many years. Talk a little bit about that experience.
Yeah, litigation's terrific for clients, at least from an educational perspective, because I see where the problems are. So when I'm drafting documents, there's a reason for every provision in these documents. And when you actually have the real life litigation experience, you get to actually see this stuff unfold in court and see where it goes. And it helps you be a little more careful in the drafting side of it. And you know where to look, for potential issues. So it's great to work with somebody that has litigation experience.
Yeah. You're licensed to practice law. Why is that? Can somebody who is licensed in New York practice here in California?
If they don't have a California license, they can't practice here in California.
Right. So
There's no reciprocity.
yeah, all estate planning laws are state driven.
That's correct. It's
Okay.
state by state.
Yeah, and so you're listed on the bar website. And why should people look you up?
To make sure I have a valid and existing license. It's important
Yeah,
that whatever attorney you go with, check the state bar website. I
yeah,
believe it's calbar.org.
yeah, and then it will tell you whether or not you've been disbarred or et cetera. So
Yeah,
you
it'll say
always
if your
want somebody,
license is active.
yeah, you want somebody who's active and that doesn't have any negative marks. What does it mean to be a certified specialist?
Well, certified specialist is you have to take a second bar exam uh, specific to a particular area of law. In my case, I took a probate trust and estate bar exam after my initial bar exam, as if the first one wasn't enough. And so obviously I passed the probate trust and estate bar exam, and then you also have to have recommendations from other attorneys and judges, and then everything has to be submitted to an entity that's with the State Bar of California, and then they ultimately approve you. And
In other words, certification has meaning.
it does absolutely. It means you actually you at least pass a test that says you know what you're talking
Yeah,
about.
but there's about 20,000 in the state of California, state planning attorneys. I'm guessing at that number, but only a small minority are certified specialists. It's a significant degree or a license. Um, you practice law in California, and you always put your client's interest first because they're the ones that are paying you.
Of
And
course.
speaking about paying, scroll down a little bit and tell us how you are paid.
So for me, it depends on what type of case I'm working on. If I'm doing estate planning, I'm preparing wills and trusts and powers of attorney, advanced healthcare directive, that sort of stuff. I usually bill on a flat fee basis. So there's no
And what
surprises.
is that?
So a flat fee is just a set dollar amount. So I
Yeah,
explain to them, I'll
I'm
prepare all these
single,
documents.
have approximately $1 million in assets. What would you charge me? Remember, I'm a friend.
Well, without going into that side of it, typically for a single settler, in this situation, it sounds like you'd need a trust because you have $1 million.
Yes,
You want to avoid probate, and we'll
yes,
talk more about that later. But
yeah,
you'll need a trust, a will, an advanced healthcare directive, a power of attorney. If you have a house, you're going to need a deed to transfer the real property into the trust. There's an assignment to the trust, the HIPAA release. There's some other documents.
yes.
But for all that, I usually charge $29.50.
29.50. If I was married, what would you charge?
$39.50 is the married couple. So
Okay.
tax
And
on
the
1,000.
reason for that is?
Well, there's more work that has to be done, more documents, more
Yes.
questions, more meetings,
Yeah.
there's more that
Yeah.
goes into it.
Okay. Do you give a free phone or in-person consultation?
For anybody that comes from this program, I do.
Okay.
Normally what I do is I charge 50% of my hourly rate for an initial consult, but for this program, I like you, Pete. You're a good guy.
Thank you. But and this is it got I'm stuttering, but I wanted to. What I'm trying to say is that it's a genuine benefit. The only thing that Fred has or attorneys have is their time and expertise. So giving away time is huge. So if you're going to take advantage of the situation, please keep it somewhat brief, so that you so that Fred continues to offer a free session to future workshop attendees. Um, uh, what is your hourly rate?
It depends on what type of matter it is. Typically, if it's an unlitigated, just like a trust administration, usually I bill $4.95 an hour. If it's litigated, I usually bill $5.95 an hour. I mean,
And
litigating
then,
stuff's a little more stressful.
yeah. And then you have other staff in your office as well. Are they at a similar rate?
I mean, they're all at the same rate or lower. I
Yeah.
mean, I have
Okay.
paralegals. They bill at 225 an hour.
And does your flat fee include a deed to transfer, or is that an extra charge?
I usually I charge for the recording fee.
Okay.
So it's just because it's a cost, that has to be paid. But
Yeah.
there's no additional attorney's fees.
What is the recording fee today? Is it
But
still
it depends on what document you're recording. It depends on if you live in the house.
okay?
Because there's a $75 fee that they charge, and if it's
Yeah.
you live in the house, they're not going to charge you the $75, but it
Yeah.
could be anywhere from like $25 up to $125, somewhere
Yeah.
thereabouts.
We're during the program for the next 6 weeks. We're going to hear the word depends
Well, that's because
extensively.
you have a lot of attorneys telling you.
Okay.
Yeah, yeah.
So, what is the reason? The reason for that is that different attorneys have different opinions.
Of course.
Um, uh, Situations could be factually, could be slightly different, and therefore the answer would depend on the facts.
Of course.
Um, it's hard to give a definitive answer to questions, I believe, in the estate planning area.
Again, it's fact specific. It depends on the
Yeah, it
circumstances.
really is. So, and there's a lot of vocabulary. So this is the introduction part of the program. If you're confused, make sure that you ask a question. There's a button on the bottom of your screen that says questions. Feel free to ask a question, and we'll get to it either separately at the end or as we're talking about it during the program, we'll get that question answered for you. Scroll down just a little bit more. Do you offer or sell annuities, insurance, or mutual funds on the side?
No, I don't
Do
do
you
any of that.
give or offer referral fees?
No, I don't.
Okay. And then what is the significance of signing this under penalty of perjury?
Well, it means I'm telling you the truth.
Yeah. And if you're not telling you the truth, in a court, what would happen? Your credibility would be no longer there, or whatever you say
Well,
wouldn't.
perjury is a criminal offense.
Okay. So that's
So,
pretty serious.
yeah, of course.
Yeah. I don't think the normal consumer would understand that. So how long did it take you to fill this out? Was anything offensive?
No, not at all. It's
By the way, it's
straightforward.
very difficult to offend an attorney, right? Isn't that?
Well, especially if you do litigation, your
Yeah.
skin's a little thicker.
You can't offend an attorney, especially a litigator. One of the things about when the client comes into you, what do they need to bring?
I always request that they bring copies of any existing estate planning documents. If they had documents prepared in the past, I'd like to see them. It impacts what I'm going to do. And then secondly, I usually request that they bring in account statements, recent account statements for their financial accounts. I want to see how stuff is titled. I do also ask if they have any account that has a beneficiary designation on it, that they obtain a copy of the beneficiary designation form. And then during the meeting, I go through everything with them because in this area of law, you got to look at every single asset and go one by one. Like, okay, if I was to pass away, how is this account going to transfer, or where's it going to go? And so that's part of the process. I usually, before I meet with the client, if they own real property, I ask for the address, and I've got a title rep that I work with, and I contact my title rep. I give them the address. I say, can you give me all deeds going back to such and such date? Typically the date, a date before they purchased the house. And then I get the chain of title, and I could see how stuff is, see if there's any issues with title or if we're in good shape and what
What
needs
we're
to
going
be.
to learn in the program is that title
Yep,
is so important, how you own assets.
correct.
And we'll talk a little bit more about that. How about family situations? Do you need to know if I have a happy marriage or an unhappy one? Do you need to know how well I get along with my kids?
Yeah, I need, yeah, I mean, you got to keep in mind when I'm drafting these documents, God forbid the client passes away and then there's litigation afterwards. Well, I go back to my file and if it ever goes to court, I'm going to be a witness and I'm going to be explaining why they disinherited this person. So I need to know all of that information. I mean, you got to be very open and candid with the attorney.
Yeah, Judge, this is not a time to keep a secret. There's an attorney-client privilege so that whatever you tell the attorney is kept in confidence.
Correct. And you
Uh,
can't be compelled, even in a court of law, to disclose what was
yeah.
discussed between you and your attorney.
And it used to be in the estate planning area, it was all about avoiding taxes. And there's still a part of that if you have a fairly large estate. But today it's all about trying to draft a document that serves the family interest and the family
Most definitely.
dynamics.
Yeah, you need a document that's going to stand up upon attack.
Yeah, yeah.
That's the way it is.
Being a litigator, you kind of see the downside of the society because most of the time, 80% or more, there's usually not a problem within a family and the estate.
When you do litigation, you see the drama, the real drama.
Yeah. And as we go through, you're going to point some issues out to us where we may want to make sure that we're careful in drafting our documents. Let's go to the your outline. In the meantime, one of the questions that we received is that I'm in Nevada, and how do I find an attorney in Nevada? Um,
Oh, of
should
course.
they go to the local bar association?
Yeah, the bar association will have a lawyer referral hotline or program. I would imagine. I mean, California has it, in every county. So
Yeah,
I would imagine Nevada's the same.
yeah. The service that I use a lot is if I'm looking for an attorney in another state or another city, is the Elder Law organization, and it's
Hmm.
called the Academy of Elder Law Attorneys. And you can put your zip code in there, and it'll give you a list of attorneys in that area. So that's the Academy of Elder Law Attorneys. And those attorneys are, that's a whole area, new area, kind of a focus for individuals, the attorneys that are just focusing on government benefits and Medicare and special needs. And that's their kind of a niche and specialty.
Yeah, there's so many different areas of law. It's unbelievable.
Yeah, yeah. Even in the estate planning area, I, I, one of the things is that I certainly wouldn't hire a litigator for personal injury to handle an estate planning case.
Absolutely. Yeah, no, it's a different beast.
Yeah, you've got to find the right attorney for your issue. So let's go through your outline, Fred.
All right. So let's see, page 2, 3. We don't need to get into that stuff. You tell me where you want to start, Pete.
Yeah, I think this is important. Talk a little bit about the documents and why they're important, and and it's important to know for you to know what the goal is.
Yeah, so I mean, a typical estate plan consists of, well, if you have let's say you have more than $500,000 in assets. The typical estate plan is going to include a trust. It's going to include a will. It's going to have an advanced healthcare directive and a power of attorney. Those are the core documents. And each one serves its purpose. Can you tell me how much you want me to get into each
Yeah.
one?
Well, we're going to get into titling in just a little bit.
Yeah.
We're going to get into probate a little bit. We'll talk about the benefits of a trust. We'll spend a very little time on estate taxes because the number is so high.
Yeah.
Step up in basis, that's something that's really important for us to know. We'll get into that. And we'll talk a little bit about the property taxes and the recent changes. So the first thing we're going to be talking about is title. But before we get into that, every one of us should have a list of assets on a yellow sheet of paper. It doesn't need to be formal or in an Excel spreadsheet where we have the asset name, let's say a house, how we have it titled, the cost basis, and we'll talk about that in a little bit of what that means, and then market value. So if you know those four things about, or yeah, three things about your asset, that's really important because your attorney will want to know all of those factors as to what you own. So what happens when an individual has a property or an asset in their own name and no documents?
Well, chances are, yeah, if it's a real property, then if it's here in California, you're gonna have to open up somebody's gonna have to open up a probate administration. And in the state of California, if you don't have a will, state of California makes your will, and it's called the laws of intestacy. So if you have a spouse, uh, depending on the character of the asset, if it's community property or separate property, either the entire value of the asset would go to the spouse or a portion to the spouse. And if you have children, that would impact it too. If you don't have a spouse, and so they'd be divided equally between your children. If you don't have children or any issue means people below you on the family tree, then the state of California's rules of intestacy say then it goes up the family tree. So first it goes to your parents, and if your parents are predeceased, then it goes to your siblings, and if they're predeceased, then it goes to your nieces and nephews, and if there's none down that line, then it goes up to your grandparents, and then it trickles back down. So it's a process.
It's the laws of intestacy. So
Correct.
every one of us has an estate plan. So if you have things titled in your own name, we always think about estate planning at the time of death. But what happens if I have a stroke or I have dementia and I have assets titled in my own name? Who gets into my bank accounts and IRAs and if what happens?
So the state of California has a procedure it's known as a conservatorship. It's like a guardianship for somebody over their age of 18. And so somebody would have to file a petition with the court seeking to be appointed as conservator of the person and or estate of the individual that now lacks capacity, is unable to manage their finances or manage their personal care. So yeah, you have to go to court and somebody has to be formally appointed by a court, and court issues an order, and that person takes that order to the bank, and then the bank will transfer the funds that are in the conservatee's name. Conservatee is the person under the conservatorship. Conservator is the person that's like the guardian, the responsible party. And then they would open an account under the name of the conservatorship, and then you'd have to report back to the court on a periodic basis. File accountings with the court. There's a lot to it.
Yeah. So give me a time period. What would it take? Let's say I have a stroke. I need somebody to go into my bank account. How long of time-wise would it take for that individual to get to that bank account?
So it depends on the county in which you file it, because different counties.
Let's say here in Orange County.
Okay, so if you file it here in Orange County, it takes about 4 months to get the first hearing on the general petition for appointment of conservator. Now, if there's an emergency circumstance, like the house is going to be foreclosed on, or something, there's
Major.
Major issues, you can apply to the court for on what's called an ex parte basis. That means it's quickly.
Yeah.
And seek appointment of a temporary conservator, and you can usually get that within a week to 10 days.
But most times that's very difficult to get. Most times, so before I can have access to the money, a year is not unheard of.
Oh well, and if it's litigated, if somebody files objections to the petition for appointment of conservator, it easily could be more than a year before anybody can access the funds. So it's important to have your documents.
Approximate cost?
An uncontested conservatorship, usually to establish it, just the general, I'd say, including court costs, the filing fees, $3,000 to $4,000 just to get it established. But then there's ongoing expenses because you got to file accountings with the court. And there's additional petitions, and there's a lot that goes into it.
Yeah. So seems like having assets in your own personal name is not really that not highly recommended.
Well, it depends.
See, there goes depends. Of course, there's going to be situations, but for most individuals, if you want to avoid a conservatorship, if you want to have somebody be able to step in quickly, you probably want to look at a trust.
Power of attorney and a trust, yeah.
Yeah. So, so in having title in your own name is probably not as desirable. Would you go along with that, Fred?
Yeah, I mean,
It depends.
I
I
won't
know.
say it. I won't say it. But I mean, you got to have documents in place.
Yeah.
You got to protect yourself, and you know, in the event of an emergency, in the event of, I mean, God knows things, you know, bad things happen, sadly.
Yeah, and especially as we age. What does tenants in common mean?
Tenants in common, it's a form of how you can hold title to an asset. So if you own let's say you own a house, or for instance, my brother and I, we have a condo in Big Bear. We each paid 50, you know, 50/50. And so we hold that as tenants in common. And so if one of us was to pass away, sadly, we probably, well, not my half is in my trust. So my brother's is not in a trust. I got to talk to him. But so God forbid he was to pass away, we'd have to open up a probate for his estate to transfer that his 50% interest in the property to, you know, if he has a will,
Yeah. So tenants in common is a way to hold property jointly, but it does not avoid probate.
correct, exactly right.
Okay. So joint tenancy, that's a probate avoider. What does joint tenancy mean?
So joint tenancy is another form of ownership of an asset. So when, for instance, if it's real property and it's held as joint tenants, so upon the passing of one of the joint tenants, by action of law is what they say, the deceased joint tenant's interest transfers to the surviving joint tenant. So if I held that property, you know, the Big Bear property with my brother as joint tenants, if he was to pass away, I would get his share. I wouldn't have to go to court, you know, wouldn't have to open up a probate for his estate. It would just automatically transfer to me. Or if I was to pass away and we held it as joint tenancy, he would get that, my half of the property.
So if a married couple owns their home in title of joint tenancy, what might be the negative aspect of having it in joint tenancy?
Well, the problems always arise upon the passing of the second spouse. So, okay, if it's in joint tenancy and then the first spouse passes away, okay, now it's entirely in the surviving spouse's name individually. And then upon their passing, well, it's in their name individually. So now you're gonna have to open up a probate.
Yeah. And technically, does a joint tenancy get a full step up in basis upon the first joint tenant to die?
No, it only gets a step up in basis as the 50% interest that was transferred.
So a joint tenancy issue could be from an income tax point of view when you sell that property after the first spouse's death. You may have more taxes to pay income tax wise if you hold it in joint tenancy.
Correct. It's a yeah, capital gains issue.
Yeah. What is community property and what is property with right of survivorship? What's the difference there?
Well, so community property is when a married couple or domestic partners, you know, let's say they acquire an asset during marriage, the law presumes that it's community property of the marital couple. And so, well, community property right of survivorship is, it's kind of like joint tenancy, but it's got additional benefits to it. So if you're married and you're holding an asset with your spouse, community property with right of survivorship is better than just joint tenancy because it goes back to what you just said with the step up in basis. Because if it's community property with right of survivorship, you get 100% step up in basis upon the passing of the first spouse, and so typically that would mean less capital gains tax in the event of a sale of the property by the surviving spouse.
Yeah. Do you have a slide on step up in basis or should we chit chat on it now? I can't remember if you do or not. But I'm going to talk about it just for a little bit.
Yeah,
Let's
let's
say
talk about it.
I purchased a stock for $100. It's now worth $1,000. If I sell that stock, I have a $900 gain.
Correct.
And that gain, I have to pay a capital gains tax on
Yeah, and to
if I hold
calculate,
it over a year.
well, you have to pay capital gains tax on it if you hold it less than a year, but
Yes,
it's a
less
little
than a
different.
year as
Yeah,
well.
yeah, it's
Yeah,
different rates
yeah.
depending
So
on.
I pay a $900.
So
If I
yeah,
hold it as joint tenancy, I would only get a step up on 50% of the gain.
so again, a step up in basis is something that occurs upon the passing of an individual that owns an asset.
Yes.
And it doesn't apply to all assets like retirement accounts, 401k, IRA accounts. That doesn't apply to that. But let's say you have a house. Yeah, upon your passing, typically the basis is what you paid for the house or the asset. And then, so if you sell it, you calculate the gain based on the difference between the sales price and the basis. Again, the basis being the value you purchased the house at. But if somebody passes away, the IRS and Franchise Tax Board, they say, all right, well, now the basis is the value as of the date of death. So let's say you inherited a house from your parents. Well, from your the second parent to pass. Well, if you receive the house entirely yourself, well, now your basis is whatever the value was as of date of passing, and not what they paid for it. Now, I mean, there's also the rules with gifts because gifts.
Yeah, let's talk about that because this is really important. What if I gift my stock to my son and what would be his basis on the stock?
So he would take whatever your basis was.
And so $100. So if he were
Correct.
to sell it, he would have to pay a tax on that.
Yeah. So the scenario is, well, this is what happens. A lot of times people, they're not doing well. They, anticipate that they're, going to pass. So they come to me, they say, oh, I want to just give this house to my son now. And I'm like, that's not a good idea because then you're going to give your son, or whoever you want to gift it to, you're giving him your basis. And presumably, a lot of times people have owned houses for many, many years and they purchase it at a pretty low price, relatively speaking. And so then the son would take it. And then let's say the son the next day wanted to sell it. Well, or let's say then the dad dies. So again, the dad transfers it to the son. Week later, the dad dies, and then a week later, the son sells the house. Well, his capital gain is going to be based on what dad paid for the house. So it's a sales
Yeah.
price minus what dad paid for it. Now, the alternative option is, and what I would tell the client is, I'm like, it's not a good idea to give it to your son right now. Just put it in your will or your trust that you're giving it to him, because then when you pass away, it's still in your name or in the name of your trust, and then you get the step up in basis. So let's say it was worth $1,000 on your date of passing. Well, now your basis, the son who just received that asset, received it with a basis of $1,000. And if they turned around the next week and sold it, well, and let's say they sold it for $1,000, you got no capital gains.
Yeah, it's
So,
huge for a married couple. So, because what happens many a time is that somebody who's lived in the house for 30, 40 years,
yeah.
one of the spouses die, and then to get the full step up in basis, a lot of times the surviving spouse wants to buy down a smaller unit. And so at least the tax issue is not going to be there to be concerned with. So please, no title. There are ramifications to that. When somebody receives a gift from you through a will or a trust, and let's say I have a daughter, does that automatically, if she's married, come community property for them, or does it stay separate property?
So again, California is a community property state. So when you're married, you got to look at each asset and classify, is it community property or separate property? Separate property is assets you bring into the marriage, or it's assets you inherit. So in your scenario, if I was to give my daughter, a house, that'd be her separate property. I mean, she could make it community property by, doing some stuff,
Yeah.
but now there's a presumption that it would be her separate property. And it gets a little complicated if you transfer it to both of them. Was it a gift just to her, or was it a gift to both of them? And it gets more complicated, and
Yeah.
that's where litigation comes in.
We're going to talk about a trust in a little bit, but that's probably the best way to hold title for most people.
Especially, yeah, if you have a house, you need a trust.
Yeah, especially here in Orange County. How would title read?
It'd be, John Smith, comma, trustee of the John Smith Trust dated, you know, April 18th, 2025.
Yeah. Is it important for you to put your deed in a safety deposit box?
You should put it somewhere safe.
But
But
recording is usually the best.
yeah, because I mean, even if we don't know where the original deed is, I can get by. I get that the deeds you can get them from the recorder's office or
Yes.
from a title rep. That's how I get.
If you own a corporation, an LLC, an LLP, uh, uh, should you have that owned by the trust or as a separate complete entity?
No, it should be owned by the trust. I mean, there's additional language you got to put in the trust depending on what type of business it is or what type of, if it's a S corp or a professional corporation. But that's for the attorney to deal with.
Okay. Someone asked, what's the basic cost of a conservatorship? I'm going to say $5,000 to $10,000 easily within the first year.
Well, because you also got to keep in mind that the conservator is entitled to fees, and there's a
Yes.
lot of work that goes into these things.
Attorneys are entitled to fees, but easily $5,000 to $10,000 in the first year.
Yeah, I think I mentioned just to prepare and file the petition and give notice and show up
Yeah.
at the hearing. I mean, and then
It's
it's
a
like
lot of work.
$500 for a filing fee alone. So,
Yeah. How long does it take you to put a trust together for a married couple?
I mean, if they need it done expeditiously, I can do it, within a week or so. But usually
Typically.
usually it's 4 or 5 week process.
Okay, a 4 or 5 week process. How many hours do you kind of put into it now? You've done hundreds, probably thousands of trusts now. So, but typically you still have, what is it, 5 to 10 hours meeting with clients?
Easily, it's always more. I mean, so there's initial consult. That's usually an hour, hour and a half, and then I have to draft the documents, and then we send them to the client for review, and then usually we have a follow-up telephone call to review the documents, or sometimes it's again in person, and then we make any additional edits that need to be made, and then we send those back to the client, make sure that the client has to approve everything. It's a process, and then we schedule the signing meeting here at my office, and so the client comes in, and I have notaries on my staff, and we go through the documents page by page, make sure everything's according to their wishes, and then they sign the documents, and then I prepare a binder, a 3-ring binder, and put copies of all the estate planning documents in a 3-ring binder, and then the originals go into an envelope, and it's all provided to the client, and then everything gets scanned into my system, so I have records.
And where should they put all their estate planning documents again in a safety deposit box where it's safe?
Well, the problem with that is how are they going to access it? You pass away, you were the one that had access to it. They don't have access to that safety deposit box. So no, it's not a good idea to put it in a safety deposit box. You could put a copy of them in there, but it's not a good idea.
No, put it on a shelf. I haven't ever heard of anyone stealing estate planning documents.
I have.
But usually it's family members.
Yeah, no. I mean, a lot of people, you have a drawer that you put your important paperwork and put it in the drawer.
Yeah. It's let's go to your next page. That's your education.
There we go.
We talked about community property and separate property. If I was if we were in a class, I would ask if there's any other questions. Is there anything in here that you see that needs further discussion?
I mean, obviously, if a married couple has a premarital agreement, like a prenup, that might impact things. I always ask a client, do you have, prenup or postnuptial agreements?
Let me ask you a question. Somebody who's planning on, let's say they're 50 years old, married, getting married for the first time. they don't really want to do a prenup. Can they put their separate property into their own living trust? And would that help keeping it identified as separate property?
Absolutely, because yeah, you can do it what's called a separate property trust, and it's just keeping it's ensuring that you don't commingle.
Yes.
It helps in the event of a divorce or in the event of your passing. It
Yeah.
helps classify as a community property or separate property. So
Yeah.
yeah, absolutely.
I think it's a lot better than a prenup. But I always want to be in there on that conversation when a
I know
loved
I'm
couple have.
divorced. I'm divorced, so I think a prenup sounds pretty darn good.
Yeah.
If I have to do it again, I didn't do one. I
Yeah.
learned the hard way.
Let's go to the next slide. Ah, that seems like such a simple question. What is an estate? Um, Everything you own, isn't it?
Yeah, yeah, absolutely. I mean, it can be complicated or it could be simple. I mean, depends on what you own.
Yeah, it's life insurance. It could be your uh, timeshare. It could be a limited partnership. Um, it could be unpaid employer wages.
Yeah,
Everything that you own.
yeah. I mean, when somebody comes into my office and they tell me, "Oh, well, my parent, my dad just passed away and my mom passed away years ago." I'm like, "All right, well, what are the assets? How are they titled? And yeah, let's figure out what needs to be done."
Yeah. Um, are we? I don't know the rest of your outline, Fred, but do you want to talk about a little bit about the estate planning documents, or do you have slides that go through each one of these?
I think we have, uh, yeah, we go through each one.
Okay, let's go through each one briefly because we next week, for example, we're going to go into an hour and a half on the Advanced Healthcare Directive and the Durable Power of Attorney. So let's talk a little bit about them now. What is the Advanced Healthcare Directive, and is that unique to California?
Is it unique to California? I don't, is
Yes,
it?
yeah, it is. It's not a living will, and it's not a power of attorney for medical care. They call it an Advanced Healthcare Directive.
Yeah, years ago it was you'd have a durable power of attorney for healthcare, but
Yeah,
nowadays, yeah, it's just an advanced healthcare directive.
yeah.
So,
So,
I mean,
what does
advanced
it
healthcare.
do, and why is it important?
So what happens is when you don't have the ability to make medical decisions for yourself, well, this document appoints somebody else as your agent to make those decisions for you. So let's say you have a stroke or you're in a car accident, God forbid, and then you're in a vegetative state, and well, somebody's got to tell the doctor what to do, and so the doctor's going to look to, oh, is there an advanced healthcare directive? And if there
Yeah.
is, who's named in it? Who's the
This is
first
the
person?
motivation for the workshop series. My father was in the hospital and he had a perforated colon. And he came out that operating room on tubes and being intubated, could not talk. And I have three sisters. We did not have an advanced healthcare directive. And so and we were all in disagreement as to what my dad wanted. And so consequently, they took the safest route, and that is they kept him intubated, and we never talked to him again.
Well, the
So
advanced healthcare directive is really good because you're picking the person that you believe would make the right decision, the decision that
yes,
you would want made. And
yes,
so,
not about the person, the family. It's what you want.
well, yeah, a lot of times, if you have multiple children, this one's, into this type. Like my brother's a doctor, and I'm the lawyer, so my parents, I'm pretty certain on their paperwork, yeah, losing charge of their medical stuff, which I don't know if I agree with that, but it's not my decision to be made. And then I'm in charge of all the financial stuff in the event that something, God forbid, was to happen to my parents.
And please have the conversation, but you need to keep this up to date. Does it get stale or old or it goes out of date?
Oh, some of the old ones, actually,
I
they'd
think
go,
it's 1997.
yeah, they'd go 7 years. But nowadays, they're generally they last, forever. but unless they're revoked, obviously. But things happen. Let's say people pass away or just they go a different route in life, and you're like, I don't know if I want that person making those decisions, or if they've passed away, you should probably go and have it looked at again. Like, maybe I should name some other people, or name an additional person given the passing of one of my named agents.
Yeah, uh, it's from my point of view, because of my experience, it's one of the most important documents in an estate plan, and you've got to have a conversation. And we'll get more into this next week. Durable powers of attorney, what are they?
So, a durable power of attorney for finance is a document wherein you name an agent to be responsible for assets that are in your name individually. So let's say you have an IRA account. IRA account's going to be in your name individually. Federal law requires that it be in your name individually. Well, if you lack capacity, you were in an accident or had a stroke, and you're no longer able to, to actually, to write checks or to understand what's going on with the money. Well, again, the agent that you named in your durable power of attorney for finance can go to the bank and transact on your behalf. I mean, the bank may request that you bring the person in or have a doctor's note, but I mean, you can get that. The agent can get that stuff done. But again, it's appointing somebody to be responsible again for assets in your name individually, not assets in the name of the trust. And we'll talk about that in a moment. But again, just stuff if you have a checking account, it's in your name individually. Well, the durable power of attorney names who can access that and when they can access it.
Yeah, and it's also true for IRA accounts, KEOs, 401ks, 403bs, assets that are not in the trust. You're going to need, if you want to have another person help you, they need legal authority. And the legal authority is granted through the durable power of attorney. I was in Wells Fargo yesterday, and I asked them whether or not they accepted a bank's client document, and they said they will accept the document, but they'll send it to their legal department to get an okay. And then in addition to that, they want the client to complete Wells Fargo's power of attorney.
I mean, yeah, some banks have their own powers of attorney. They've got their own legal department that has their own opinions on what's important. But the problem is, what if that client, the client, if they lack capacity, they can't execute a new power of attorney. So sometimes the bank, they don't understand real life.
Yeah, they don't. But the point of the story is check with your bank. Check where you have your IRA account or your 401k. See if they'll accept your durable power of attorney. And prior to you having to need to use the document, make sure they accept it. And we'll go in more detail again next week on this. Let's go to the next slide. Hey, if I have a trust, why in the heck do I have to have a will?
So the will it's kind of like a safety net. In the event that something didn't get properly titled into your trust, well, your will is going to say everything goes to my trust. So the scenario that occasionally arises is, okay, you go to the estate planning attorney, they draft you a trust and will and power of attorney, advanced healthcare directive. And then, you take title to, they transfer your house into the trust. And let's say that 5 years later, you sell the house and then you buy a smaller house or a different house. And then when you take title to it, you take title to that new house in your name individually. You forgot, I'm supposed to put it in my name as trustee of my trust, but it didn't happen. Now it's in my name individually. Well, then when you pass away, well, that house is still sitting in your name individually. I got to get it to my trust. So then in that situation, you got to open up a probate, or somebody's got to open up a probate, presumably the person named as executor in your will. And then they got to get a court order to transfer the real property to the trust so it can be distributed pursuant to the terms of the trust. And so the trust is the real document, but you need the will to make sure that anything that somehow didn't get properly titled in the trust.
Does a will have any effect while you're living?
It does not. No.
No. So it's a worthless document while you're alive, but when you're dead, that's when the will comes into play. And
Precisely.
and the terminology is, if you have a good estate plan, your will would be what's called a pour over will. And the pour over stands for transferring it to the trust.
Yeah, so the asset pours over into the trust.
Okay. Let's talk a little bit about a trust. What is a trust?
So trust is it's a legal document that sets forth, one, how titles to be held for your assets. So you got to keep. So it'll name a trustee. A trustee is like the manager of the trust, and then it'll say, you're the trustor or the settlor. The trustor and settlor, that's the person who establishes the trust. It's their assets that are in the trust, and so the trust instrument will say, during your life, the settler, slash beneficiary is entitled to, unfettered access to principal and income. And then upon well, if it's a married couple, it may have provisions, that come into effect upon the passing of the first spouse. And it gives directions to the trustee on how they're supposed to handle the funds. And then upon the passing of the second spouse, who are the beneficiaries. So it lays out all this, all
It's
that
like a
information.
contract.
Yeah, exactly. Exactly.
Like a contract, you make an agreement as to who's going to be helping you if you die during your lifetime. Is there anything extraordinary that people have to do? Do you have to change social security numbers or
No, for a
change your
trust,
tax forms or?
for a typical trust. I mean,
Yeah,
there are
I
trusts
know it
that are more
depends.
complicated. I'm not getting into that right now.
But for a typical trust, life goes on exactly the same way.
Yeah, you may have to go to the bank and change the account to your name as trustee, but it's still under your social security number. And, it's called a grantor trust. I don't want to get too much
Yeah,
complicated,
no,
but
life goes on the same as you would before. The good news is it avoids probate and it could avoid a conservatorship.
yeah,
It's
stay away from
so
the court if
much
you can.
easier. Yeah. For a single person, gosh, it's almost mandatory, I think, that they have a trust.
Yeah.
Because it's so much easier to work with in Orange County if you become ill and there's no one there to help you. Your successor trustee steps in.
Yeah, and again, so it's very important that you know how assets are titled, because if it's in your name individually, well, that's the durable power of attorney that would kick in. But if it's titled in the name of the trust instrument governs. So, and the
It's
trustee.
much easier to work with a trust than it is under a durable power of attorney.
Yeah, it is.
Banks don't like them. People don't understand them, but pretty much people understand a living trust. So your basic documents for a review is a will, advanced healthcare directive, durable power of attorney, and each person, if you're married, needs one of those, and then you can have a living trust together.
So yeah, again, if it's a married couple, so then I'm preparing 2 wills, 2 powers of attorney, 2 advanced healthcare directives, and 1 trust.
Okay, we talked about how long it takes to put together a basic trust. How should cars be titled? Should they be named in the trust?
They don't have to be. What
No.
happens is if you have assets that are in your name individually, and the combined value is less than, I think it's 184,500. That's I didn't
We
make up
don't
the
even
number.
report cars. We just go directly to Auto Club and the DMV.
Yes,
and
that's the
transfer.
only thing that the DMV is easy about.
Yeah.
When a person dies, that's
Well,
the only thing that they're easy on.
I still
Everything
like
else is
Auto Club better. Yeah, and make sure if you're married or you own it with another partner, put in or, not and. So you don't even have to make a change upon the death of the other partner.
Yeah, and that deals with the joint tenancy versus the tenants in common distinctions.
Yeah. Someone asked, what would a separate property trust cost? Is that just your standard set fee of approximately $3,000?
Yeah. So again, yeah, I would do a trust, a will, power of attorney, advanced healthcare directive, but instead of calling it, I mean, again, you could have 2 different, each spouse could have their own separate property trust if they wanted to.
Yeah.
You don't really see that often, but it happens from time to time.
Yeah. Yeah, especially if they're getting married later in life. How many people would you recommend naming as an agent in your advanced healthcare directive?
I usually say minimum 3.
Yeah. And do you, some people go, hey, I've got two kids. I don't know. I don't want to offend them. Should I name them as co on all these documents?
I don't like naming codes because uh, a lot of times, yeah, if one of them doesn't agree with the other one, then you got problems. You might have to go to court to solve the issue if because it requires unanimous, agreement. And so I don't, and on top of that, especially like after the parents pass away, when they're co-trustees, things change. People's minds are different. It's a strange phenomenon, but it's real life. And
Yeah.
so I don't know. I've represent. I had one case where there was co-trustees, and whatever the one brother said to the other brother would say the opposite.
Yeah,
And
they
it
didn't
was
like each
both
other.
ways. If
Yeah.
either whoever said something first, the other sibling was going to say, "No, that's a horrible idea. I want to do it this way." It just eventually I had to fire the client. I'm like, I can't. Like, you're not being logical or realistic or reasonable. I'm like,
And emotions within a family are not reasonable. And so you need to tell the attorney if you suspect that there's some issues of communication within your children. That it's a really important to let your attorney know.
yeah. The best way is you pick one person. Who's going to be the best at the job. Go with that person, number one. In the event that they're unable or unwilling to act, who's number two? They're unwilling or unable to act. Who's number three? That's just keep it simple.
Yeah. We're going to go through trust administration in session in week 6. So we're not going to get too much into the detail of this. But when the first spouse dies and they're both named as trustee, does it, do you need to remove the name of the deceased spouse from your title?
You should, yes. And if you're
Should.
real property, you're going to record an affidavit, death of co-trustee. Um, but
So
yeah,
there's a little bit of work that has to be done when the first spouse dies, but the major work happens after the second spouse.
exactly. And also you got to keep in mind that when you set up accounts, it's usually, a financial account. Usually it's not under both social security numbers. There's a lead social security number. If the account is under the deceased spouse's social security number, you got to change that. You got to put it under the surviving spouse's social security number.
Okay. Um, let's go to the next page.
All right.
Let's talk about probate. What is it and why is it important?
So probate's a court supervised process, for administration of an estate. So when somebody passes away, well, if their assets sitting in their name individually, uh, if
It
the value,
changes, the court changes title on assets.
well, the laws, there's laws in effect as to, how stuff needs to be handled, and it's the court overseeing the
Yes.
administration of the estate. And so, yeah, here it's required when the value of the combined value of the assets exceeds 184,500 right now. That number changes from time, from year to year. Like 20 years ago, it was 100,000, and then it went up to 150, and then it started getting adjusted for inflation.
Yeah. So if you own assets, let's say you you have a $2 million trust and you have all of your assets except for $200,000 that you have in the bank, entitled in the name of the trust. That 200,000, does that have to go through probate?
There is an exception. I won't get into that, but generally, yes, that
Yeah.
would require. So you have a trust, but then you still have to do probate. So
Yeah.
it's frustrating. When I see that happen.
Yeah.
It's
And it
like,
happens
we
a
did
lot.
trust. Yeah, no, because people don't
happens.
think about it's title.
Title. Even if you have a checking account, put it in the name of your trust.
Yeah, it doesn't hurt.
So probate is required if you have monies in your own individual name. If I have a trust, do I go to the probate court?
You're not required to.
But when could I end up in the probate court?
Well, let's say the trustee's not doing their job right. The
Or
beneficiaries.
there's a disagreement amongst the beneficiaries.
Yeah, that could pull the matter into court.
Yeah.
It's just so unbelievably easy to file litigation with the probate court and to fight over this stuff. I mean, it's just easy to have different perspectives and positions on how things should be done.
Yeah, and it's highly emotional usually.
Yeah.
Well,
Yeah, I'd say, but our area law, it's not as emotional as family law, but it gets pretty close.
it
It's
gets pretty close. Yeah. Let's go to the next page.
yeah. Oh, did you want to talk about the small state affidavit real fast?
Well, that if you got an estate smaller than the 184,000, there's a 4-page document that you can handle the probate
Yeah,
process.
if you pass away and you only have a checking account, let's say the checking account had 50 grand in it, and that's your only asset. Well, then your beneficiary or your heir can fill out the affidavit, sign under penalty of perjury, attach a certified death certificate, provide it to the bank, and then the bank will say, okay, we can handle, transfer the money to you as the beneficiary without opening up a probate. So
Yeah.
it's
If you have a totally dysfunctional family, you may want to have a judge sit in on the issue. Sometimes you even don't want a judge there. But possibly if you owe an immense amount of money at the time of your death, what is the statute of limitations for creditors on under a trust and under a probate?
well, so upon your passing, creditors have basically a year to go after the money that they're owed. So, and if they fail to do so, then the statute of limitations ran. So you're barred from bringing it and fighting in court about it. So, but there's also a process. You're supposed to file a creditor's claim with the court, but to do so, you got to open up a probate. So it's a little complicated, but it's nice if you have a trust, then you don't have to open up the probate, and then you didn't provide a forum for the creditor to come after after your estate. Creditors don't want to throw good money at bad, so they're not. The chances are they're not going to open up a probate for your estate to go after the money. So having a trust, it has some benefits as it pertains to creditors. So
Yeah, and then the creditor is 4 months under probate.
So what happens is you can give a notice to creditors. So after you open up a probate, you serve what's called a notice to creditors, and then they have a period of time in which to file a creditor's claim. And then if they file the creditor's claim timely, well, if they don't file it timely, then they're barred, if they within that window of time. And then if they do file a creditor's claim, well, then the executor or the personal representative has to either allow or reject the claim. And if they reject it, then there's another clock that starts to run. And so, yeah, it's a process. All this stuff it's complicated. I mean, a normal person can't be expected to understand all this stuff.
No.
It's just too much.
No, I think the session is about just becoming aware of some of the issues.
Yeah.
Let's go to the next slide. Probate process. By the way, while you're talking about this probate process, is the trust administration process similar?
It actually is pretty similar. I mean, obviously, with a trust, you're not filing anything with the court under normal trust administration. But yeah, I mean, in terms
We
of
have to determine title to the assets.
yeah, you got to so when the person passes away, presumably stuff was either in their name individually or in their name as trustee of the trust. Well, in the context of a probate, well, the person would get appointed as personal representative by the court. Court would issue
He called an executor.
Yeah, if there's a will, yeah, the executor gets appointed. The executor brings that paperwork to the bank, and the bank usually will open up an account in their name as executor of the estate, and then there'll be a new tax identification number for the estate, and they'll transfer the money from the account of the deceased individual into the executor's account.
Yeah, and if you had a trust, your successor trustee would do exactly the same thing, but would put it in a trust account.
Into their name as trustee of
the a new EIN number, etc.
Yep.
Same thing.
So yeah, I mean, when it comes to probate, so you file the initial petition for probate. It usually takes about 6 or 7 weeks to get a hearing on that type of petition. And between that 6 or 7 weeks, you serve notice, and then you publish notice in the newspaper, and then the client gets appointed. The court issues the letters. You do what's called an inventory and appraisal. You send it off to the probate referee to value the non-cash assets, because you got to report back to the court what were all the assets as of date of passing, what were their values. what is the estate comprised of? And then in that process, you're giving notice to creditors in that period, and you're dealing with the taxes. And if there's a house, that's the time when you sell the house. Usually it gets sold, but unless the will says otherwise. And
Yeah.
then when everything's done, and it's been at least 4 months from the issuance of what's called the letters. The letters are the court document that says, who's appointed as the personal representative. And after that 4 month period ends, you can file a petition for distribution. So it's typically known as a first and final account. And there's a format that it needs to be in, and the court expects it in a specific format. And then usually, well, here in Orange County, that type of petition, it takes about 4 months to get a hearing date. And then
Yeah, but
give
probate
notice.
now in Orange County, they're averaging almost 2 years.
Yeah, if you could, these days, yeah, maybe. I mean, it depends on it depends
I
on
know, it always depends,
if you have
but
a
on
house and the house needs to
average,
be sold, I mean, you don't want to fire sale it, so it could
yeah,
take some time.
yeah. And by the way, what the administration for a living trust, what's the average period of time?
Uh, Under a year.
Under a year.
Yeah.
But people seem to expect it to be done a lot quicker.
Well,
And
so in
that,
a trust, after the new trustee, after the person passes, the trustor passes away, the new trustee, whoever's named in the document, steps up, and they go to the attorney usually. Then the attorney will send out what's called a trustee's notification. Trustee's notification starts the running of a clock of a 120-day period in which people can contest the terms of the trust. If they believe that the trust was prepared and executed at a time when the trustor lacked capacity, or if the trust was, established based on undue influence,
yeah.
the beneficiary,
It's
brought up to the attorney and so on
yeah,
and so
it's
forth.
the notice by mail. We take an inventory and appraisal. We look at the taxes. We look at the creditors. We sell the assets. Hopefully there is no lawsuit. And
Yeah.
and when we distribute, we do a final accounting, and we ask everybody to approve the accounting, and we ask the beneficiaries to approve and discharge us, so to speak. The process is very, very similar. Uh, there are some advantages on by the way, what's the probate cost approximately? Let's
Uh,
say $1 million
okay, you're talking about
estate.
fees. So
Yeah,
the attorney and the executor, let's say, they're entitled to the same amount as a base. It's called the statutory fees.
yeah,
It's based on a probate code section, and it's calculated as 4% of the first 100,000, 3% of the second 100,000, and then 2% of the next 800,000, and then above 1 million, it's 1%. And I won't go
yeah.
into the details of that, but
For approximately a $1 million estate, it runs about just fiduciary and legal fees somewhere close to around $40,000.
46,000 if you want
So
to be,
yeah, you got the
if you want
numbers
to be
right on the
precise.
top.
Yeah, and that doesn't count the court costs. I mean, you got filing
Exactly.
fees and e-filing
Extraordinary
charges and
fees.
probate referees,
The
and
cost of dying is approximately 3 to 5% of your net worth, just as a rule of thumb.
yeah, so just don't die. That's
Just don't die. I like that. And it doesn't depend.
it does not depend.
You do have some court supervision under probate, and you don't spend a lot up front as far as a trust is concerned, but you spend it upon death.
Yeah, so the costs of administration of a trust are less.
Yes,
But again, you pay more to have the trust done while you're alive.
yes.
So are you
And
going to pay now? Or are you going to pay later?
there is a cost. And do you recommend to most individuals have family members serve as their trustee or successor trustee? Should the family member be paid, or should they do it free for the family?
No,
And
I
don't
mean,
say depends.
the settler, the person who established the trust, wouldn't get paid because
No, I meant
your assets. But
the
the
trust
successor trustee,
administrator, the successor trustee.
yeah, the law says that they're entitled to reasonable compensation. I mean, you could change the provisions in the trust, but why disincentivize, the people to act? I mean, it's a lot of work. People don't realize how much work goes
It
into this
is.
stuff.
But some families expect whoever is named to do it at no charge.
It's
I
so much work.
discourage that.
And on top of that, it's so easy to be sued in trust law and, for not doing your job right. And
Yeah.
I mean, people
We
don't
haven't even
realize,
talked about liability for
yeah.
the trustee. Let's go to the next slide. Disadvantages: time, cost, privacy, court supervision, ease of access by creditors, easy to contest. First of all, overall, for most of us, we should be try to avoid probate.
Yeah, that's the
We
general
talked about the
consensus.
cost. Let's go to the next slide. We talked about the administration process of a trust. The advantages of a trust, again, is the avoidance of the probate, the cost. It usually is quicker, and it doesn't have to end on the death of the trustor. Sometimes kids need a continuation of the trust.
Yeah. So what's nice about a trust, something you can do with a trust that you can't do with a will, is you can leave the assets in trust, maybe for your children's lifetime. That a certain amount gets paid out to them on an annual basis, but it continues in trust, and so the trust can exist for 30 years or whatever it is, and then upon their passing, whatever's left over in the trust could go to your grandchildren. So, but you can't do that with a will. A will is like, all right, where is it going to go? It's got to go right away, outright, free of anything, free of the estate. That's under a will, but again, under a trust, the person that's establishing the trust has more say in how it's administered after their passing.
There's other probate avoiders, such as paid on death accounts, such as beneficiary designations under your IRA, but we'll talk about those in the retirement planning session, and we'll get into more detail there. Let's go to the next slide.
All right.
Disadvantage of a trust, the cost, somewhat more complicated. If you have a successor, you do have to pay for some administration. It's easy to file a lawsuit against a trustee. If we know that there's a problem within the family, can you put some special language in the trust to protect the trustee?
Yeah, absolutely. I mean, you could change the standard of care by which, they could be sued. There'd have to be like gross negligence or willful misconduct.
Yes.
There's things you could put into the trust to
So
protect the trustee.
please tell your attorney about your family. They need to know so they can maybe add some additional language. Many of the times I received, my mom told me blah, 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 blah. And I look at the trust and it doesn't say anything in there about what blah, blah, blah means. Can I still do it if I'm the successor trustee?
No, you got to abide by the terms of the trust.
No, trust
Document
is the
controls.
Bible.
Yeah.
Yeah. So you got to understand what's in the trust. Improperly funded, you mean it doesn't, the asset is not in the name of the trust.
Yeah, so again, it's that situation where you bought the house 5 years later and you took it in your name individually, even though you have a trust. Then you got to open up a probate, upon your passing, somebody's got to open up a probate, get a court order to transfer it to the trust. So you went through the whole trust or the whole probate process. And now you got to go, once it's in the trust, now you got to go through the trust process.
Yeah.
So now it's just, you
Yeah.
got to make sure title's properly,
The trust administration is not as expensive as probate. There is a cost. Let's go to the next slide. Cost to prepare a trust, we talked about that. Let's go to the next slide. Estate taxes. I'm not going to spend a lot of time on this, but the rate today is you have to have an estate of
$13,990.
okay, close to 14 million. For a married couple, it's
well, if they do the paperwork properly, it's twice that.
twice that. So if you have an issue with in the estate tax area, it's almost a volunteer tax. Your attorney, if they're given the proper amount of time, you could completely avoid paying the estate tax.
Yeah, estate taxes years ago were a big issue. They're not so much anymore, given the high numbers.
More. Let's go to the next slide. We talked about the step up in basis. It's really important. And remember, gifting means that the person takes on your cost basis. Let's talk a little bit about real property taxes. Prop 19, go through it. And
So we'll start with Prop 13.
We've got about 8 minutes.
Well, I'll go quick. So Prop 13 was back in the late 70s here in California. They did Prop 13, and that said that your real property taxes can't go up by more than 2% a year, which is nice because if you bought your house in the 70s, you're probably paying very little in property taxes relative to the person who just bought a house next door just recently, because the property taxes are established based on the purchase price. And so again, if properties have gone up faster than 2% a year, but your property taxes wouldn't. So that was Prop 13. Then Prop 58 said that you could transfer assets upon your passing to your children, and they could keep your assessed value, your real property taxes. Now that came out, I think it was like 86. But then the problem is, I think it was 2021, Prop 19 came out, and that eroded away most of what Prop 58 did. It was nice before because you could if you had multiple houses, let's say you had like 4 houses and you had, 4 kids, you could transfer it all, each one could get a house and they could keep your real property taxes, like that low number. Whereas now with Prop 19, it botched it all up. I'm not a fan of Prop 19. So now it's okay. If it's your principal residence, you can transfer it to a child. If they're going to live in it, then they can keep your property tax value. Otherwise, it's getting reassessed. So the state of California is making a lot more money through Prop 19, but it all has to do with the real property taxes. You got to pay on April 10th and December 10th.
Yeah, make sure if you have real estate and you're planning on giving it in kind to one of your kids, please understand it. And that's another thing about, don't gift it during your lifetime. You lose Prop 19 for part of your value of your home, I believe. Is that correct, Fred?
No, not exactly.
Okay.
But again, you might not. You might lose some things that you could have benefited with by transferring it through your will or your trust.
Yeah. So most times it's beneficial to give it at death.
Yeah. Well, whenever I'm looking at these things, you gotta understand there's different types of taxes. So you gotta analyze each situation from an income tax perspective. Then you gotta look at the real property tax perspective. Then you gotta look, is there an estate tax issue? What are the impacts on that? Are there
and property
gift taxes? There's just a lot you got to be thinking about.
Recent changes in the estate law.
Yeah, so you could gift up to $19,000 to somebody, and you won't have to file a gift tax return. If you
don't have to pay a tax, you can donate $25,000. You don't have to pay a tax.
Yeah, but you'd have to file a gift tax return. That's
okay.
The issue. So if you want to avoid having a gift tax filing requirement, just keep the gifts under 19,000. If it's a married couple gifting something to a child, obviously you can double that. So you can give 38,000. But that's where the number is nowadays. It used to be lower, but each year it's been going up.
We talked about the federal tax exemption. We talked about if you have assets in your own personal name, 184,500. Is that new? Trust can be terminated. The value does not exceed 100,000.
The number's gone up. So what happens is when a trust falls below $100,000, the trustee can elect to terminate the trust.
Wow, that's huge.
Yeah, that's nice.
New life expectancy tables for the required minimum distribution. We're going to be talking about that in the retirement planning session. So we're not going to get into it here. Step up in basis. Thank God it's still here.
Yeah, they keep talking about changing it, and it's
politics.
A lot of politics.
It's one of the biggest benefits for families, not to pay income taxes upon the death. So hope it stays. And we talked about Prop 19.
Yep.
Next, your last slide. Talk about it.
Yeah, I mean, as it says, you got a lot of choices in estate planning, lots of things to think about.
It's very personal.
Yeah. Yeah.
You know, try to avoid going to a trust mill, somebody who offers the amount of time that it takes to develop a good relationship with your attorney and understand the family and the assets. A trust mill doesn't take the time to do that.
Yeah, they're not going to spend the time to explain it to you.
Yeah,
I mean, they'll pump out a product, but who knows if it's right?
You know, let's say if you have $1 million trust, you know, the cost of doing a good estate plan is less than 1% of the value of $1 million.
Yeah.
And so maybe think of it that way. You don't give a free toaster when you do an estate plan.
Well, no, I do not.
You know?
But it's
You just all you hand them is a paper.
yeah,
with
but I'm
nice
also
binder.
I'm educating my clients. You know,
Yeah.
I'm trying to make sure that they understand everything, at least at that moment. I mean,
Yeah.
again, it's a different language. You
Yeah.
know, the world of trust and
Maintain
estate.
an inventory of your assets and debts.
Well, you
Really
gotta
important.
keep in mind that your successor trustee or your executor, um, they're not you. They don't necessarily know what your assets are. You know,
Yeah.
it's like they got to play detective. Make it easy on them. Prepare, you know, a single page that just identifies all your assets. Make it simple.
How you have a title, how you have what your cost basis is, what the estimated market value is. You don't have to have the absolutely correct number. Keep you informed about your assets and debts. You know, procrastination is probably the biggest reason for people not doing an estate plan.
Yeah, I mean, some people they don't want to face the fact that you know we're all going to go someday. Some people
Yeah.
just it's too much for them.
I was going to call the program "It's Your Death," and somebody said, "Don't do that." Use professional assistance. If you're an engineer, don't do it yourself. Please use an attorney.
Well, it's like if you don't file your own taxes generally, you go to CPA.
Yeah,
Like for your estate plan, go to an attorney. I mean,
yeah,
it's much
yeah.
safer.
Hey, it's 11:31. We right on target. Thank you so much, Fred. This is awesome.
Yeah, my pleasure.
We're going to end the program right here for purposes of the video. And next week we'll go through the Advanced Healthcare Directive and the Durable Power of Attorney, two of the most important documents in an estate plan. And we'll have a different attorney that will join us. And thank you for being here today.